ladies and gentlemen. Welcome back to the Modjeska Simkins School for Human Rights. Today, we are honored and privileged to have two very special guests joining us today. In fact, so special that we had to have the Supremes introduce them. What I'm going to do right now is briefly turn the floor over to Brett Bursey to introduce our guest, and we'll get our program started this afternoon.
Thank you, Dr. Green. And it is indeed a humbling pleasure to introduce these two gentlemen. I've known them since I was a child, and I didn't appreciate them then. And as the decades have passed, I remember meeting Armand Derfner. I knew Armand Derfner, but I ran into Armand one time, and we figured the close we can come is sometime during Jimmy Carter's administration, and he was president for those of you that weren't born then. And I'm walking down the mall, and here comes Armand Derfner with Jody Powell and Hamilton Jordan, the president's chief of staff and communications director, acting like it's normal to be walking around with them. And it was all uphill from there for me with Armand, because Armand is all over South Carolina and the South in general, mostly, dealing with cases of racial suppression and voting and representation. And a really brief and endearing story about Armand. I didn't know that he was born in Paris, as his parents were fleeing Hitler, until I recently read his intro in his book. But that the wonderful part about Armand that I remember now is one of the cases that he had here in South Carolina, many cases about equal representation in single member districts, probably in the 80s. A mutual friend of ours, who is one of the plaintiffs, told me this story. They didn't know Armand. This is a majority Black county. Armand can tell you which one, maybe. But I'm talking about Armand Derfner, and this person who was one of the plaintiffs in the county said, we didn't know. And Armand's not a very presuming fella, and kind of slight and a little bit wrinkled, like a professor or a lawyer with a seersucker suit on. And they go to Justice Department. They've got depositions or testimony or something, and he takes the plaintiffs to Washington, D.C., and they go in the Justice Department. And he said, we went in there and doors were flying open and people were yelling, Armand Derfner's in the building, like he's some kind of rock star. Armand Derfner is a rock star, and we're really lucky to have him. And he's going to talk about, hopefully, some of those cases he's won in the Supreme Court. And my good friend, Vernon Burton, I wish I had known him when he knocked on Modjeska Simkins' door. And can't quite remember. Those of us that are old enough to have been doing things like this in the 70s can't quite pin it down. But he was doing his PhD work on Reconstruction at Princeton. And so he decides he's going to chat Ms. Simkins up, and he knocks on her door in the early 70s, goes in and talks with her probably till it got late at night. And if I know Modjeska, she'd offered him a glass of port. And she said, where are you staying? He said, I don't have a place. She said, well, you can stay here. And we're lucky Vernon didn't just move in and stay there, because he went on to finish his degree and has been one of the nation's leading scholars on Reconstruction. Lincoln's Unfinished Work is one of his recent books. And the work that he's done with Armand goes back together with him working as a historian, putting the history of racial litigation, legislation, and laws in context, and Armand arguing the cases going back to the 1980s. And so I want to read just a little bit from the introduction of their book, which I thought was just so telling about these lads. They're not just academics and legal scholars, nor is their book. Race and Supreme Court are at the center of this drama, talking about the book. But major roles are played by two other actors, time and law. Time is fundamental for understanding race in the United States. American slavery and Jim Crow prevailed for over 300 years, and they have been gone for just over 50 years. If we count a generation as 25 years, then American history has consisted of 12 generations of white supremacy and barely 2 generations of trying, sometimes more aggressively than at other times, to overcome it. But time and law can also undo the inequality they created. That undoing is the role of the 13th Amendment, adopted after the Civil War to abolish slavery and bring universal freedom throughout the land. Though in recent years it's been largely cast into the shadows of constitutional doctrine, except for occasional appearances, the spirit of the 13th Amendment is at the heart of the Constitution. That spirit animates this book. We're so glad to have y'all. Dr. Green, take it away.
All right. Thank you so much for that great introduction, Brett. And I wanted to have us start off actually with Dr. Burton this afternoon, talk a bit about his book, Justice Deferred, Race and the Supreme Court. It is an excellent work that the two of them worked on. And I think it's a great book if you want both an introduction to how the Supreme Court and race have interacted over the last 200 plus years, but also it's a good, thorough text on how so many of these Supreme Court decisions still affect the country today. So, Dr. Burton, I wanted to turn the floor over to you to just talk a bit first about the book itself, what inspired the creation of the book, and to really get into how ideas of race have influenced the Supreme Court over these last 2 centuries.
I'm happy. Maybe the easiest way is I'm feeling sort of like deja vu all over again, to go with one of Armand's favorite metaphors, which is baseball metaphors. There's a lot in this book. I took out as many as he'd allow me, but he's such a baseball fan that we had a lot. 1980, we were in a crisis in particularly voting rights, but civil rights law as well. There had been a case, Mobile versus Alabama, in which the judge had found that, in fact, the laws discriminated against minority, in this case, African-American voters. They would not be able, under the at-large system as it existed, to ever elect, or had not been able so far to elect candidates of their choice. And the Supreme Court decided it did not matter if those laws discriminated, but in fact that one had to show that the intent of the policymaker, those stakeholders, was to write those laws so they were intended to keep Black voters from electing candidates of their choice. And of course, lawyers, attorneys, civil rights attorneys, like Armand Derfner, like my great friend and his friend Lachlan McDonald from Fairfield, South Carolina, who was sort of running the Edgefield case, which they had been arguing about 8 years or so, I think, when I got involved, realized that this is something that historians do. I remember some wag in a newspaper, may have been the Time, but saying, what are they supposed to do? Dig up those policymakers out of the grave and ask those corpses, did you intend when you wrote that law in 1911 to keep Black voters from voting? But that's what historians do. We study intent, purpose, and motivation. And so we can be experts with that, or trained in ways to do it. And so that's when Armand and I first met, was in the Edgefield case, which in itself could be a book, I suspect. And we began talking about these issues. And I don't remember exactly when it was, but at some point, Armand, who was teaching at the College of Charleston Law School, it's not College of Charleston Law School, is it?
Charleston School of Law.
Charleston School of Law, was teaching a course on a case book and said, I'm thinking about doing a book on this. Would you do it with me? And I never say no to Armand about a case or anything else. I tried to say no to a lot of things in the book, but I got outvoted. That my wife had the final vote. She always voted with Armand. But I was lucky that he asked me to be involved, but we really had been discussing these issues for 40 years, and we argue about them. We still argue about them as we wrestle with how to move forward in this country, hopefully in a way that can make a difference to bring about what we both believe is the center of what this country is all about. That is equality, and certainly equality under the law. So that is how we really started the book. And we actually did our first draft, or rather outline, at Penn Center, where I had written a book about Penn Center. And we were there at one of Brett's conferences, I believe, of this group. Is that not right, Brett? And Armand and I went out on a picnic table with one of my students and began to outline the book about 2014, 15, something like that, and began writing it. And we liked the book very much. And I do have two quick quotes, and maybe I should shut up and let Armand do it, but I think this is what's important. Brett talked about the generations, but I sort of late in life became a fan of the Adamses, the Massachusetts Yankee, having grown up like most Southerners, liking Thomas Jefferson, and then discovering that it really was Adams, and the Adams family were much more of the abolitionists and small farmers and just didn't talk about it. But one of the Adamses, Henry Adams, and the education of Henry Adams, actually, I remember the page, I almost have memorized, page 308, said that the American mind, and I quote here, stood along in history for the ignorance of its past. If we have anything, if the legislators have anything to do with it, they're going to work very hard to make that a reality yet again. But it was sort of the founder of that family, the one think of, John Adams, who was the second president, had a quote as a historian I really like. Facts are stubborn things, and whatever our wishes, our inclination, or the dictates of our passion, this cannot alter the state of facts and of evidence. And that's what this book is. It is evidence. And I think that evidence points to conclusions that anybody that has any rational mind at all cannot help but come to see and agree with. And my hope is that the truth will set you free, even in an era of alternative facts and the dangers that we've unleashed in terms of the ideas that you don't need to have evidence to make an argument. Armand, I know there's a lot more you probably have to say and a lot you disagree with that, but is that a get at Robert's question, or did I completely use your techniques as a lawyer and evade it and say what I wanted to?
All sounds right to me. Sounds right to me.
Well, on that, I'm glad that you asked Mr. Derfner to also chime in, because I'm curious about what in particular pushed you to say that we need a book on this particular topic. Because, as I said at the start of our conversation this afternoon, it's such a wonderful work of history, and I think an important work of history. So, Mr. Derfner, why did you approach Vernon Burton in the first place to say, we've got to put this in book form?
Can you, before Armand talks, can I jump in one more time to finish it up? I really believe this. I've said it over and over, and I've heard Armand say he thinks I'm right. This book had never been written before, though it should have been. You have a lot of books on Dred Scott. You have a lot of books on Jim Crow, but you don't have anything that looks at race from really before we have the Constitution, in our case, right through 2021, that puts it together to look at the patterns and things like that. And I believe no historian could have written this book. I know I could not have. And I'll let Armand really speak to it, but I don't know of most legal scholars who could, or lawyers who could. And I think that was the beauty, even though it was a frustration, was that this is a co-authored book. It's a joint effort by a historian and an attorney, or maybe I should say, since Armand really started it, an attorney and a historian. And it's about people, not just the law, but it's about people. That's important. Now, Armand, how's that?
That sets it up perfectly. Yeah, no, what's unique and special about this book for us, and I think it is proven to be that for people who read it, is that it is a history book and a law book. And in fact, I'll go a step further. Vernon says, and I agree, it could not have been written by just a historian or just a lawyer or legal scholar. But I'll go a step further. Vernon is not just a historian, he's half a lawyer, because he has been involved in these cases as expert witnesses. And Vernon knows as much about legal doctrine and the way courts work and the way the Supreme Court works as most lawyers in this country. And I pride myself on being something of a historian too. I majored in history in college. And I won the prize, the history prize for the department while I was there at Princeton, where Vernon got his PhD. I got my AB. So it's written, it's not just a historian and a lawyer getting together, but it's two people who both, I would say, are immersed in both those disciplines. And so we've put together something that draws on our history and draws on the law that has been made throughout our history. So let me give one example right now of how that fits in today. One of the words that has come to play an important role in the Supreme Court nomination of the about to become, I believe, Justice Jackson is the word originalism. When people were asking her questions, one of the questions they asked her was, do you believe in originalism? Originalism is a school of interpretation of the law that has acquired some almost a dominant place among especially conservative justices and judges and since the 1980s. The late Justice Antonin Scalia popularized it, and it's the idea that if you want to figure out what something in the Constitution means, because the Constitution has a lot of very general language, you try to figure out what was the meaning, what was those words understood at the time of the framing. So a lot of the justices, especially the conservative justices, they've gone back, say, to the Second Amendment, and they said, well, the original understanding of the words in the Second Amendment, they say, I quarrel with it some, was that it was an individual right, and that's what's given rise to these Supreme Court holdings in the last few years that take the Second Amendment and create a very broad individual right on people to kill each other and just lay out the neighborhood with guns and shootings. And they say that's originalism, and that's how you interpret the Constitution. You go back to what the founders, in those cases, the founding fathers, what were the words they used and what did they mean? That's originalism. So when Justice Ketanji Brown Jackson, or about to be justice, was asked, well, do you believe in that? She said, yes, I do. And so you have articles now in the Wall Street Journal and other places saying, hey, wait a second, is Justice Jackson going to be a conservative? Well, we talk about originalism in the book too, because one of the major themes in the book is that judges, when they write opinions, justices, of course, when they write opinions, they have choices to make. And the choices they make about what the words mean in the Constitution or in a statute, those choices reflect their values. And if you want to talk about originalism, well, originalism is a fine thing, but it should not be understood to mean just the originalism of the first 10 amendments, which were drafted by the founding fathers in 1791. We have a bunch of founding fathers. The founding fathers were, to be sure, John Adams, Alexander Hamilton, James Madison, but we also had the Reconstruction Amendments in the 13th, 14th, and 15th Amendment, which revolutionized the country, which really gave us almost a second constitution, certainly a new role for the Constitution. And we had new founding fathers. We had Abraham Lincoln, Frederick Douglass, and Thaddeus Stevens were the founding fathers. So the original understanding of the 13th, 14th, and 15th Amendments, which, as the Supreme Court said at the time, before they started moving backwards, was designed to elevate a race, to free a race, to protect a race, to provide equal protection, and to protect the newly freed slaves from unwelcome and unfriendly actions by people, states, and private citizens who had been trained over 200 years to be hostile. And that's what those amendments were, and that's what the civil rights laws are designed to do. And so if you really believe in originalism, and I'm willing to believe that maybe Chief Justice Roberts does, and the new Justice Jackson may, then you need to believe that the 13th, 14th, and 15th Amendments get absolutely full interpretation, full value, and they should be interpreted for all their worth in terms of their original understanding. And the civil rights laws should be interpreted that way. And the interesting thing is that they were not done that way during the late 19th or early 20th century. They were given full expanded value and taken seriously in the days of the Warren Court. And unfortunately, today, they again are being put back into the background. And that's one of the things our book charts. And it charts it against what we say is a way to look at what justices do, remembering at all times that justices have choices. And when they write their decisions, they are reflecting their choices and their values. And the values that the Supreme Court ought to be reflecting are absolutely as much for the 13th, 14th, and 15th Amendments as any other part of the Constitution. So
I like to say, from my perspective as a person of faith, that is the new covenant of the Constitution. And unfortunately, for some of these originalists, not all, like Judge Jackson, I have hope for the others, that I've always said one of the main problems with the American South, with its commitment to evangelism and things like that, that most of us are very slow readers. And there was a big mistake not to put the New Testament first and the Old Testament last, because they just hadn't got to it, or things would have been a lot different. So maybe we should start with the 13th, 14th, 15th Amendment and read forward, and then go back to the original Constitution, so they would understand that this is not only part of it, but changed the Constitution. Or as I like to say, that, you know, basically Lincoln, who claimed that he would be remembered for anything, the most important thing he would ever do was Emancipation Proclamation. I think not as important as that was. It was the 13th and 14th and 15th Amendment, putting positive liberty into the Constitution. And even more important, I think, taking what is, I consider, our sort of ideals, that is our mission statement, the Declaration of Independence, and putting it into the Constitution, our rule book. And I really think that's what the 13th and 14th and 15th Amendment are.
let me just
Should be
say something
interpreted
about that.
that way.
Let me add one more thing. One of the things we talk about in the book is federalism. And federalism is often regarded, or the term is often used by conservatives as a notion that the states have a lot of leeway and a lot of freedom to act the way they want to. Unfortunately, as the South shows, and now increasingly other parts of the country, the states have typically used that as a way to do bad things. Well, we show in the book that at crucial times in history, the Supreme Court has recognized that federalism does mean states, does focus on the states, but it means state responsibilities and states' obligations just as much as states' freedom or states' independence.
Now, I'm glad you two brought up Reconstruction in particular. And this actually takes me to my next question. And I want Dr. Burton to tackle this one, but Mr. Derfner, you're also welcome to chime in as well. What about, because your book gets into this some too, what about the particular role of South Carolina in some of these cases with the Supreme Court and race? Could you talk a bit about how the Palmetto State has had an impact on the Supreme Court and race over time?
Oh, you know, it's a book. There's so much, and we had to narrow it down. And I don't want to minimize the earlier period. I mean, it really does start out with South Carolina, but the central thing I like to point out to people is South Carolina, everywhere you go, almost every courthouse square, there is a statue to the Confederacy, often advocating that it was for white supremacy, almost using those words. And sometimes it does, such as in Anderson. And you I think Armand made me take this out of the book. I can't remember what's in and out. And I will say this, Armand has said it before. I think he's right. We're sort of proud. We don't know who wrote what because I think we argued over every word. And sort of, as I said, when it came, probably it was Armand's words because I said every time we asked my wife to vote, she voted with him. He's got a way with women, so be careful. But you think about it, the Civil War is certainly important in American history, but for modern America, the court case that changed America, that gave rights to old people like me, to Native Americans, to Hispanics, to all groups of equal rights. It is the Clarendon case, where my favorite illustration in the book was taken by the magnificent Cecil Williams as either a 13 or 14-year-old, just as Thurgood Marshall is getting off the Silver Meteor in Charleston to argue Briggs v. Elliott. Here is an extraordinary story of great heroic heroes of not only Briggs or the Briggs case, but that whole community of the Reverend Delane, Joseph Delaney. Just an amazing story of people who gave up everything, have never been recognized, and did it all for their children, as opposed to Brown, not to take away from Kansas and Brown and Reverend Brown. Reverend Brown is the only man who's on that petition. The rest are all women. These were families, Black and white, fighting for their children. They've never been recognized, and yet they changed America as part of, I think, that 13th, 14th, and 15th Amendment really started in the 1930s, but in the 54 Brown decision, which should have probably been named the Briggs decision, or at least something to recognize what it would have been. So that is a major, there are a lot of important cases, a lot of precedents, a lot of other things, but that case is maybe the most important, and it has to be understood that it really began. And of the 5 cases, the only one in the Deep South is from Clarendon, South Carolina, with this extraordinary group of people. And I believe if you want to go into memorialization and monuments, it's like we did in Greenwood with Benjamin E. Mays. The way you take care of the Calhouns, though Armand shows you can take down a Calhoun statue in Charleston, but a better way even, I think, is to put up those who went against the grain, those other stories, those other who I would say as truly heroes. We may not need heroes anymore. That was part of my generation that we didn't, but we know that role models are important. We also know that people learn their history, not from the books historians write or my grandkids would have a lot big education fund, but from those things that we tell them are important. Those historic houses. Therefore, I'm so glad you have a Modjeska Simkins home being recognized. But you need particularly the kind of memorializations that we have of statues of Ben Tillman on the State House ground, Wade Hampton, Strom Thurman, and James F. Burns. Every statue of an individual was someone who either argued strongly for and supported slavery, the Civil War, or segregation. So I think it is critical that we also recognize, and this is just one of many examples, but clearly that group of individuals, African Americans from Clarendon County, who were led by Reverend Delaney, in what becomes Briggs v. Board, it becomes Brown v. Board, that then sort of morphs into the 1964 Civil Rights Act that affects us all today. Yeah, that's just one. But Armand, we could even start with Native American cases and end with in South Carolina. You want to speak to more? There's a lot more in South Carolina that are important cases.
There's a number of ones, but I think it's outstanding that, as Vernon points out, that South Carolina led the way in the school desegregation case with Briggs versus Elliott, Reverend Delane, so forth, because otherwise, frankly, South Carolina, as we know, doesn't have a very good record as far as contributing to the welfare of this country. It was South Carolina delegates to the Declaration of Independence Convention in 1776 that forced Thomas Jefferson to take out the section condemning the slave trade. It was us, of course, who started the Civil War, etc. In our book, unfortunately, we have South Carolina as the last ditch place in a number of ways. For example, when Congress finally passed the Voting Rights Act in 1965, it was South Carolina who challenged the act and took it to the Supreme Court and got their pleas rejected when the Supreme Court upheld the Voting Rights Act. And South Carolina was basically trying to argue for John C. Calhoun's theories. It was also South Carolina when the Supreme Court threw out the white primary, in other words, a rule of the Democratic Party that only white people could vote in the primary. The Supreme Court threw it out in 1944. Other states grudgingly complied. South Carolina was the last ditch. It took till 1948 before South Carolina would finally throw in the towel. Along the way, they said, well, yeah, anybody can vote in our primary. You just have to take a loyalty oath that says, I hereby swear that I support racial segregation in every aspect of life. And if you didn't sign that, you couldn't vote in the primary. And Judge Waring said, that's just nonsense. And he threw it out, but South Carolina kept on fighting till the end. So we do have a role in the Supreme Court in this book. And if it wasn't for Briggs versus Elliott, Reverend Delane, and all the folks up in Clarendon County, it would be an almost unbelievably negative role.
And the interesting thing, though, is no one's ever recognized that. I will say, Armand, that South Carolina should get credit with ending slavery because, you know, there hadn't been a civil war. I mean, it was a horrible way to go, but that was not their intent. But
well, let me add one more thing. This is sort of interesting. Somebody asked me this question not long ago. Has South Carolina had any Supreme Court justices? This was when there was a possibility that Judge Michelle Childs, who's an outstanding judge, might be the person nominated. Turned out she wasn't, but so somebody asked, well, did we have any Supreme Court justices? And I'm sad to say that our record there is not too good either.
But we did.
We had two justices. One was John Rutledge, who was named to the Supreme Court by George Washington. He was on the court very briefly, and then he said, the heck with this, I don't care about this. I'm going back to join the South Carolina Supreme Court. So he walked off the U.S. Supreme Court, I think almost as soon as he was named, about 1790. And then 5 years later, there was a vacancy for Chief Justice of the U.S., and George Washington said, well, I'll try John Rutledge again. And he nominated him, and the Senate, U.S. Senate of that time, 1795, I think, said, well, the heck with you. If you didn't want us then, we don't want you now. So that's John Rutledge. The second person from South Carolina on the Supreme Court was Jimmy Burns. Jimmy Burns, who was as racist as he was a good friend of FDR. He was named to the Supreme Court in 1941. And fortunately, he got off the Supreme Court after a year also. He got off to do work, important work to be sure, in World War II. But he resigned from the court, sort of thank goodness for the Supreme Court, because otherwise he'd have been on the court when the Brown versus Board decision came along. And it seems very likely that as stubborn a person as Jimmy Burns was, he would have dissented and written something that would have embarrassed South Carolina if he'd been on the court in 1954.
And Armand, I disagree a little bit. I think James Burns was so talented. Here's a man like Strom Thurman. They might be, except for their racism or their defense, maybe that's not fair to say racism, their defense of segregation might be a better way and a more appropriate way to say it. May have had monuments to them on the mall along with Martin Luther King Jr. They were so talented as politicians. He was called the Cardinal Richelieu of the Senate. FDR would have probably chosen him if he could for his vice presidency. He would have been president instead of Truman. He was Secretary of State. All of this without ever finishing high school. Pretty much his father died, from Charleston, really, originally. So he's very talented. I'm not sure he was so influential that the court could have even gone the other way. Now, Armand thinks it.
I'm going to interrupt you and squeal on you. This is fascinating because we had one of these conversations, one of these book discussions last month or 2 months ago. And in that discussion, we took just the opposite position. Vernon was the one who said at that time, well, if Jimmy had been on the court, he probably would have dissented in 1954. And I said, well, maybe not. Maybe he would have changed over the years and become a person who could come to see the wisdom of that. So it's we can change each other's minds.
Yeah. Well, I think I'm still consistent. I don't think he had come. He was still fighting it here in South Carolina. South Carolina led the fight against Brown v. Board. He was the one that hired Davies, who was considered the greatest Supreme Court lawyer of his time, even though we both think it was Thurgood Marshall, that really hired Davies, of course, to argue for South Carolina and all of segregation. And he really came back to be governor to preserve segregation. So I don't think he would have changed. He'd already been Secretary of State. He had been domestic president, basically, of the United States, and he hadn't changed. We both agree he would have dissented. You say he might have grown to have accepted, but I fear not, because he didn't, and he should have. My problem is, I think he was so influential that he might have brought others to have stayed with him on this, and it could have easily gone 5-4. The wrong one. Instead of Warren getting a unanimous verdict, which is amazing when you think about it.
Let me spring off of the Brown versus Board of Education case to bring out something else there, where I think the history that we bring to this book is really an eye-opener for a lot of people, and frankly, a lot of it was for us. Everybody says, well, we all know that Brown versus Board overruled Plessy versus Ferguson, which was an 1896 case in which the Supreme Court had said separate but equal is okay, it's constitutional. And there was discussion, you remember at the time of Brown, about whether that was right or not, whatever. What people don't know, almost nobody knows this, but it's prominent in the book, is that 20 years before Plessy versus Ferguson, the Supreme Court had said unanimously, separate but equal is bunk. They had rejected it when remember, Plessy versus Ferguson involved a black man being kept out of or being arrested for being in the white car.
And he looked white.
20 years earlier, a woman named Catherine Brown had been kicked out of the white car because she was black. She brought a lawsuit. She won the lawsuit in the lower court. And when it got to the Supreme Court, the railroad said, well, they didn't use the word separate but equal, but they said these cars, the white car and the black car, are equal in every respect. They're equally comfortable, equally safe, equally convenient. And the Supreme Court said, that's just subterfuge, a unanimous opinion, absolutely rejecting separate but equal. So Plessy versus Ferguson just ignored that. So when people back in the 50s or 60s said, well, Brown versus Board of Education is violating precedent, they needed to look a little further because Plessy versus Ferguson had been violating precedent. And that's sort of an example, I think, of how we've brought some things to light that people didn't know about beforehand.
Right, and if memory serves, that Supreme Court case you're talking about was Railroad Company v. Brown from 1873. Is that right?
Yes.
That's right.
Okay.
And it's sort of interesting, Ms. Brown is clearly visible as an African-American woman. Homer Plessy had to tell him he's black, basically, because he wouldn't have recognized him. So that just shows you how things have changed in that period of time. The Supreme Court defended a clearly identifiable black woman's rights to have equality, and a African-American man who could easily pass for white was the case that brings about supposedly separate but equal, but was never equal.
Right. And a couple of things before we move on. Number one, for folks in the audience, if you want to ask any questions, go ahead and write those questions in the chat and we'll get to them as soon as possible. But in the meantime, we'll wait for some questions to start coming in. I did want to ask you two gentlemen, and I feel like I'm obligated to ask about this at this point, starting with Mr. Derfner. Could you talk a bit about, because it's been in the news so much in the last year or so, the main ideas behind what we call critical race theory, because this has been in the air so much, and I think every Modjeska session I've gotten questions about it as well. So could you talk to the audience a bit about what critical race theory actually means? Because I think most folks in the media portray it as one thing, but in fact, it has much more to do with the legal system and the law. So could you talk a little bit about that to our audience this afternoon?
Okay, critical. If it weren't so important and so tragic, it would be funny what people are doing with it. Critical race theory actually is a term invented by, or coined by Professor Derek Bell, who died a couple of years ago, a law professor who, in fact, was working at the NAACP Legal Defense Fund and was involved in Brown versus Board of Education. But basically, all it boils down to is recognizing how much of a role race has played in things where people think, well, it wasn't race at all. And the example I like to give is the Texas-Mexican War and the Alamo. And so, we grow up thinking, well, Alamo was those brave Texans fighting against those nasty Mexicans because Mexico was oppressing them, and that's why they wanted to be free. Well, it doesn't take long to figure out, if you go a little further, say even to college, that Mexico had ruled against slavery. And the people who were fighting in the Alamo, including some people from South Carolina, Captain Travis, Jim Bowie is not from South Carolina, but Travis were fighting to preserve slavery. They went to Texas because they wanted to have slaves. And so critical race theory is recognizing that the Alamo was about slavery. And just lots of what the book shows is that all kinds of things that people say, oh, that didn't involve race. Well, they did involve race. So a good example is we learn all kinds of things now. We learn that major universities in the Ivy League were founded by slave owners and slave traders. Georgetown University was one of the largest slave owners in America when it was founded. These are things we didn't know. We thought, we were taught when we grew up that race was a minor aspect. It didn't affect much. What we know now is that race was central to so many things in America. And that's what critical race theory is. I think that's all it is. Recognizing how much of a role race has played in the decisions that we have made in this country.
All right, and Dr. Burton, would you like to add anything to that?
Well, I'm afraid I don't think people know what it means, and I don't think anyone is teaching critical race thinking. I think one of the problems, we aren't teaching enough being critical or thinking critically. But I fear that all it is what's become nowadays what we call code words. It's like that one party has used things like abortion, transgender rights, gay, lesbian rights, and things as a way to motivate people to vote against their own economic and social interests. So I don't think people are even interested in understanding what it is. As those of you who I've spoken here before know, I really believe that particularly public school teachers, but school teachers are doing God's work and they're doing the best they can. And for a state legislature to do something like this is just outrageous. I mean, I cannot believe how bad it is. I did a conference on Lincoln's unfinished work. Rhett was there, maybe some of the others over there, and I did a workshop for teachers who are wanting to find out how to teach about this most difficult topic that we have to face, and that is the race relations that we have had in our state, because that has affected the way people think. I mean, why is it that one group of people might look at a statue of Ben Tillman and see one thing, or a flag and see one thing, and another group see another? You need to understand why that is, why people feel as they do. These, and recognize these can be legitimate feelings, whether you like them or not, you know, from either side. And the only way to do that is to understand our history. These ideas come out of our history. It makes who we are. And to try to say that we don't want to teach them, no one wants to tell anybody how to think, at least they shouldn't, but you want them to be able to think and make up their own mind about things. So this is one of the most disturbing things that's happened, and a lot of disturbing things that's happened in my lifetime, that the idea that you don't want to teach about something that's so critically important. I've often used one of my heroes' words, those of Harvey Gantt, who was said that you may not can appeal to the morals of a South Carolinian, but you can always appeal to his manners. And I think there's some truth to that.
I think that was a joke.
I think a lot of white, I'm sorry, Armand, you were saying something, Armand?
I think that was a joke.
No, I think it's true. I think that white people in particular don't know or have any idea what it's like to be Black in South Carolina. Now, William Page, Walter Hind Page, the writer, said it would better be an imp in Hades than a Black person in South Carolina in the 19th century. And I think that pretty well, applies to the history. I've often said that white Americans think that terrorism began with 9/11 and a bombing of the Twin Towers. But for African Americans in South Carolina and most of the former Confederacy lived in a terroristic society, at least from the end of slavery until 1965. And white people need to understand, how would they feel if that had been them growing up in that society? And I think a lot of people, I was given a lecture at USA Upstate, and a couple of the members of who I debated earlier in the Sons of the Confederacy came to give me a hard time. I wasn't talking about what they thought I was talking about. I wasn't talking about the Civil War. I was talking about the Civil Rights. But when I got through, they wanted to do something to recognize the Clarendon heroes because they hadn't known this history and thing. And I think that's important. I think it's tough. It's hard to do. It's got to be age appropriate as people come along and you're dealing with some tough issues about what parents do and what the schools can do. But I think if you want to have a democracy, and I mean that, unfortunately, that if we don't want to have a democracy, and a lot of people seem to not want to, you can't have it unless you have an educated public. Yeah. And that is so critical that we need to be teaching these issues in our schools. That's our history. That's our history. Do you not want to know your history and how you get? It doesn't mean you're ruled by it. You can change. I mean, this is what I loved about Lincoln. He wasn't born, quote, the great emancipator at all. He came out as a rural Southerner. And literally, as he learned and met with people like Robert Smalls from South Carolina and Harriet Tubman and others, changed his mind so that by the time he's assassinated, he's leading the nation to a better place. But he wasn't born. It's about education. And education can be all sorts of ways, but it is important in our public schools. You can disagree, Armand. Armand, you
No,
can
no, I
disagree.
think that was an eloquent, I'd have to agree 1,000%. I'll just say this. I teach a course sometimes called Race and the Supreme Court, along the same lines as the book, the law school. And what I do at the beginning of the course is I always say, this is going to be a difficult, emotional course for you students. If you're African American, then we're going to be learning about things that your ancestors have suffered through, and it's going to be very embarrassing for you. And I say, and if you're white, especially if you're from South Carolina, and if you trace your ancestry back further, you're going to be very, very embarrassed or worse about some of the things that you will learn. I'm not here to embarrass anybody, and I'm certainly not going to focus on anybody. But as you read the material and learn about the past, it's going to be very difficult emotionally, whether your ancestors were on the quote top rail or the bottom rail. And I say that, and that's what happens. I have found people crying, both white people and black people, students crying in my classes.
You know, I think I might have said this the last time I spoke here, Robert and Brett, and if so, I apologize, but I've taught a history of South Carolina. Well, I've taught civil rights movement. I take that back. At Coastal, I think I did once at the College of Charleston. I did it at the Citadel, and I've done it at Clemson. I have yet to have a black or white student from South Carolina in that class, in those classes, from any of those schools. Now, maybe they aren't being honest, but they have not heard of the Orangeburg Massacre, which occurred when I was at Vernon, and it was one of those defining moments in my life. And yet that is something that happened in our state. It's unbelievable. How could that have happened? You know, this is 4 years after the 1964 Civil Rights Act, and you're protesting a segregated bowling alley, and 3 students are killed, one a high school student, I believe, and 27 people shot, most in the back or in their heels running away by state officials. And not to know that, to grow up in South Carolina, and that's not part of your history, and then you don't understand why certain people might not love the state and what it represents, or law enforcement in the way that you have been taught to love it. To me, you're doing an injustice to people. When people say, oh, how can children handle this? My kids, by the time they were 12, 11, 13, they watched the kind of horror movies I can't watch today. I'm scared to death of. You know, it seems to me they can handle zombies. They could handle state highway patrolmen shooting someone, but that's where we are with our legislators today, it seems to me, or at least people who are manipulating the legislators and manipulating these symbols in ways that just seems to me extraordinarily bad in American history in general. But I don't feel very strongly about that, as you can tell, Robert. So, but as a historian, it's infuriating. I mean, it's one of the, I don't usually get angry, but this really angers me. That
I don't want to chime in, but I have to. There was a few years ago, the local newspaper here in Charleston ran a little article talking about how history wasn't really taught. And they gave us an example. Well, we asked 10 people in the State House, and I forget if they were 10 legislators or just 10 visitors, who was Wade Hampton? And they said, and only one person out of the 10 had any idea who Wade Hampton was. And then in the last paragraph, they said, just for the record, Wade Hampton was a South Carolinian who served in the Civil War and as later as governor and senator from South Carolina, period. And so I wrote a letter to the editor saying, well, if you're going to really talk, if you really want to know who Wade Hampton was, let's find out who he really was. Wade Hampton became governor by leading an armed uprising, an armed, illegal, subversive uprising that used military force to overthrow the lawfully elected government of the state in the name of achieving white supremacy. That's who Wade Hampton was. So I agree with Vernon. It's frustrating, but better teaching. Maybe critical race theory is what we really need, no matter what you call
it. Right, and I think just to add to that before we get to the Q&A from our audience this afternoon, it's worth noting that both Modjeska Simkins in her attempts to do citizenship schools in the 1940s and with the Mississippi Freedom School in the 1960s, both of those emphasized history for a very good reason, because they wanted folks to understand not only what they were fighting for in terms of civil rights and human rights, and not only what they were fighting against, white supremacy, but most importantly, how to understand how we got to that point. And I will say, teaching at Claflin, HBCU in Orangeburg, South Carolina, so many of my students are astounded when I talk about things like Wade Hampton or the Reconstruction era, among other examples, things that they should have learned about in K through 12 in South Carolina, but just did not because it's not taught. Again, this is an uphill battle that we all face, and it's only being made worse, I would argue, by the debate over critical race theory. So just had to add my 2 cents in, or however much that matters.
And Robert, let me add in now my 388 million cent, since I've spoken too much. But, you know, a lot of people, this is about, quote, civil rights are about Black people. But I love this quote, and Armand and I one day privately will tell you how it got in here. This is the first illustration of the book. Harvard wouldn't let us make any more changes, but I wanted this sentence in because I think it's the critical. This is the picture, the first illustration. You don't usually see an illustration in an introduction of a book, but it's important. This is the Thurgood Marshall. And about the time he's arguing in Charleston, he said, "Sometimes I get tired of saving white people's souls." And you know, critical race theory is about saving white people's souls too. Do you not want your children to know the truth? Do you not want your children to understand who they are, how they got, not that they're supposed to be ruled by it or even be, I argue, I've taught Southern history. I taught at Illinois for 34 years in American South, you know, and it seems to me there are two extremes. One is what we've seen so much in South Carolina. Strom Thurman, you know, my country right or wrong, you know, I'm a Confederate and so proud of it. And or you're overwhelmed with guilt, and both are terribly crippling. You got to, and this is why it's important to learn your history, learn to think in terms of the larger framework and come out of it and look at the ambiguity of history and understand it is complicated and it doesn't have to rule you, just like it did not rule who Robert Smalls became, or Modjeska Simkins, or Abraham Lincoln became. It is so important. Or for that matter, James McBride Dabbs out of South Carolina, or Dr. Benjamin Mays, not just Black or white, but it's because they were able to think for themselves by using knowledge and abilities. And that's why learning that history is so important. It is about equally good for white people and white students as it is for African American or other minority peoples to know about our history.
Before I hope that before you get to the questions, we talk a little bit about the future, because anybody who's seen the book sees that we end on a somewhat hopeful note. We keep getting asked, how is it that we can have hope? And so this has been, with all due respect to everybody, including us, this has been such a downer, this discussion. We've been focusing on all the things that have been bad or wrong or negative. I want to make sure that we have a hopeful note in the book, and it's not just 100% gloom and doom. And Vernon likes to sort of focus on how we end the book and with a quote. I hope we can get to that.
Oh, please go right ahead.
Vernon, why don't you talk about what the part about the end?
Well, you
then
can
I
go ahead
will talk about one of the reasons that we believe this.
Yeah, and Armand and I struggle with this. I mean, there would be some days I would be worried about him and things, because it is a depressing story to a large extent, despite the great heroic efforts of so many people like Modjeska Simkins and others you come to appreciate as well. And I really think you ought to tell your story of the pearls, Armand, one of the gems, as I like to say, in the book that tells about the book, about just how extraordinary and how the law can rule. But maybe the easiest thing is to read this conclusion, because we did not want to leave it on a downer. We got to remember, one of the things that Armand said is that we have had 12 generations of the law teaching white privilege and white supremacy, and only 2 generations not. And I think Armand's absolutely right. So we've come a long way. We're here talking about it. We also have lessons from the past. They don't just replicate, but you can understand. It was like in 1980 when the civil rights movement was in a crisis in the law. Armand was one of the leaders that solved that problem with the 1980 renewal of the Voting Rights Act. Deserves a lot of credit about it. You can read about it in R. Berman's book. He would let me put in here his central role in that itself. But we need those abilities to come up with ways to answer the crisis we have now. We can't just sit around and be intellectual eggheads and say, oh, woe is us. Look what they're doing to us. We have examples of, here's Thurgood Marshall. He couldn't win those cases. No way could a black lawyer win those cases. He won almost all of them at the Supreme Court. It was amazing. But here's the answer. I'll let Armand then tell you why we think this says a lot about where we are in the future and why we have great hope here. In a 1951 poem, the Harlem Renaissance bard Langston Hughes asked, "What happens to a dream deferred? History shaped by the court's unfolding interpretations and limitations on rights tells us that justice has been deferred too long. Abraham Lincoln challenged us, determined that the thing can and shall be done, and then we shall find the way." We take inspiration from the young people who will be writing the next chapter. In 2019, 2020, the youth poet laureate Amanda Gorman gave readings around the country of a poem she had been commissioned to write for Independence Day. In her performance at the American Academy of Arts and Sciences, Gorman, an African-American woman, we didn't know she was going to become famous incidentally when we wrote this, so it's a little bit more detail you need to know who she was, from Los Angeles, who was a student at Harvard, explained that she sees American democracy not as something that's broken, but as something that's unfinished. Rather than falling prey to discouragement, she speaks of being audacious in taking up the mantle of our founders and playing her role in finishing their work. In her poem, Believer's Hymn of the Republic, she declares, "Every day we write the future together." And Armand explained why we believe that there really is hope there, and that what we're seeing with critical race theory, with the undermining of the Voting Rights Act is, the Confederacy's last stand at Gettysburg.
Yeah, I think, as I say, we are forced to think about this because we are always asked how, with our country in such danger now, how can we have any sense of optimism? And part of that is, as we say, we keep coming back to this notion of 12 generations and 2 generations. Well, in 2 generations, we have come amazingly far. Now, we always say also, of course, we have way far to go, but that should not obscure how far we've come. I was having lunch one day with two giants, Judge Matthew Perry, who's the namesake of Vernon's wonderful chair at Clemson, and Judge Bernard Fielding of Charleston. And both of them said the same thing. They said, I have seen things happen that I never dreamed I would live to see. And I think everybody understands and believes that there is a majority in this country of people of goodwill who want to see change, more change, and want to see fairness. We are at a crisis nowadays because some people, a lot of people who don't believe that, are trying to undermine the democracy, are trying to figure out ways that a minority can control because they do not have a majority. So we are afraid, and rightly so, of bad things to come. But where we are now is really almost would have been unthinkable in 1965. And a lot of what we see for the future, like Amanda Gorman, is the young people. And I'll just point to three things that to me symbolize how change is moving forward. Number one, 20 years ago, as little as 20 or 25 years ago, gay people were still second-class citizens in this country. We passed something called the Defense of Marriage Act, federal government, led by President in 1994 or 5. And yet today, you would not recognize where we have come with not just the rights, but the status of gay people. That's number one. Number two, interracial marriage. Again, it used to be that was a lynching offense. Today, if you see a white woman, a black man, a black woman, a white man, whatever, walking down the street, they hardly even get any attention paid to them, no matter where they are. And the third, this is a hard one. This is a difficult one to talk about, but it means something to me. George Floyd was murdered. Other black people have been killed, murdered. But here's the thing, and by police in many cases, here's the thing. When it happens, it's a big deal. There are protests, there are TV stories, there are often prosecutions. Well, you know, as little as 20 years ago, even 10 years ago, it happened all the time. It happened all the time, and nobody paid attention. Nobody's an over-exaggeration, but those were not stories. Now, when it happens, it's a big deal. That, to me, is a sort of a tragic sign of progress, but to me, that's progress too. So I just keep thinking that the next generation will be better than we were, and the generation after that will be better than they are, because we have certainly come further than the generation that came before us.
And let me give you a good insight that Armand's had too to follow up on that. And it goes along with me. I'm never trying to excuse a Ben Tillman, but some of the people believe the horrible stuff. Now, they shouldn't have. There are always people who point out otherwise, but I'm convinced that they believe these things. Today, I think most of the people saying this and are using it for political reasons, as I said, code words that go back right here to our own South Carolina campaigns that became so effective under Richard Nixon's Southern strategy, using these kind of code words are out there today. I'm just doing a case right now, SB 202 in Georgia, where I say that voter fraud, the term voter fraud, or DeKalb County are now code words because people generally, except in Texas, where I've done a good bit of work, use the kind of language that made it pretty clear what they were saying that they used to before 1980. And so, but one of the big differences is the court of those days of Plessy v. Ferguson, even though you had the great dissenter Judge Harlan explaining exactly why they were wrong, so they made that choice. It wasn't they didn't know, or even Judge Tony in the Dred Scott decision, all the way back, you have these dissents that allow you to understand they made that choice. They made knowing the alternative. Literally, I believe, as Armand has sort of taught me, that those courts sort of reflected that time period. This court today that's doing these terribly wrong decisions, I don't know how else you can say it, but they're wrong. You look at the dissents, they're usually right. They're out of step with most Americans. Remember that though Donald Trump got more votes than any other presidential candidate, still Joe Biden got a lot more than he did. Hillary Clinton got a lot more votes than did Donald Trump, though he got with the Electoral College. It really has. And to give you a great example was in 2004, I was testifying in Texas in a courtroom, and Jerry Hebert, a very good friend of Armand's, was the Justice Department, said, "Now, Vernon, don't take it personally." He'd almost had the first expert witness up the head in tears. He says, "This judge just hates expert witnesses. And so don't feel bad and don't take it personally when he goes after you." So I was ready. Instead, for some reason, he took a liking to me, invited my wife and my 5 kids to come ride horses on his ranch and stay with him and all. And at the end, he said to me some flattering things about me and asked my advice. He said, "You know, Dr. Burton, it's the first time I ever heard a judge identify himself with a political party. Before that, I sort of assumed that they did not think of themselves as Republicans or Democrats or Green Party or anything else." But he says, "You know, I'm a Republican and I'm very worried about democracy. Young people don't vote. How are we going to get young people to vote? Do you have any ideas? Because I don't think democracy can continue if young people don't vote." Well, the next time I was testifying, actually, Armand was in the courtroom then. And we've been doing it so long, it probably wasn't good. But after the LDF, NACF put me on, Armand got up and spoke, and we can sort of finish each other's sentences. So it was, got out the things that needed to be said. But I was able to say in that courtroom, you know, this is great irony, because the last time I was in a courtroom, a judge was asking me, how are we going to get people to vote? And he was a Republican. And now I'm here, and I cannot believe the state of Texas is trying to stop people from voting with an in-person voter ID. What has changed? Then it gave me a chance to explain it. And there were a lot of things. One of them is that Texas, and now the United States is headed that way. Georgia is almost there. Florida is almost there. A majority minority. And so you're seeing the effects of this as Americans come to grip with that white, primarily Protestants, are no longer going to be the majority in this country anymore. Secondly, you had an African-American elected president, and with minorities, particularly African-Americans, seeing a person they could identify with that represented them, they came out to register and vote in higher numbers than ever before. And that terrified certain whites. And then thirdly, we had that recession, and we're still having economic issues. And every time you have economic issues, you see this kind of progress that we have had come under attack as people become fearful. And so I think all of that comes together in a way that what you're seeing is the last grasp. And if we let them be successful, then maybe they can retain power. But if we can make sure that they are not successful by disfranchising people, by keeping people from voting and telling these lies, then I think that we can really make democracy work. And I honestly believe it is, as Lincoln called it, our last best hope. And we face the very same issues today. It's hard to believe. I didn't think I'd ever say this, even when Armand and I were writing a book that Lincoln did in 1860. Lincoln struggled his whole life with this issue, and I thought the issue was solved. His first speech that he ever really gave, the Lyceum speech, and read it, you'll see it. He just refined that speech the rest of his life. He kept working on the same speech till he got it right. But the issue of it and elegant is the same. On the one hand, If you have total liberty and things, you have anarchy. So can people live under, and on the other side, if you have too much of what we think of as order in that struggle, then you have authoritarianism, and in his sense, monarchy. And these are the issues not only we face with our political parties and struggle in the United States today, this is what the world is facing. And the irony is what people don't understand when Lincoln explained why he was going to war and not let the states of the Confederacy leave the Union when everybody, the abolitionists said, let them go, let's get rid of these troublemakers, was that last best hope. The rest of the world was like the Confederacy. It had moved back. After the American Revolution, you had a period in which France has a revolution, becomes a democracy. All these countries, Mexico, you were moving in that direction in the United States. We forget that, like my favorite, or one of my favorite musicals, Les Miserables, is the 1830s, where Napoleon has taken back over, and you have a monarchy in France. Napoleon III sets up Maximilian as a dictator, authoritarian figure in Mexico, which had been a democracy. Garibaldi, the hero of two continents, goes back to Italy, unifies Italy, thinking it's going to be it becomes a monarchy. The rest of the world has moved away from the idea that people can govern themselves, and not just that rich people and people who are dukes and kings who are supposedly in this hierarchical society can. And that's what Lincoln faced. And what are we facing today? But the same issues of authoritarianism, both at home and abroad. And the only thing we have is the same thing Lincoln had, us to believe in this rule of law and make sure they're applied equally for everyone. And I really think that we can do it, but means that people have to wake up and be taught to think critically about their history and to be willing to fight for what is right.
Well, these are some incredibly powerful words we're hearing from our two guests this afternoon. And all this reminds me of why I do what I do for a living as well. And speaking of which, I want to now go to the questions in the chat. We have some good questions coming in from folks here this afternoon. And I want to start with one of Greg Howell's questions. And I'll direct this to Mr. Derfner first. Could reparations to descendants of slaves, if authorized by Congress, pass constitutional scrutiny?
Say that again. Okay.
Could reparations to descendants of slaves, if authorized by Congress, pass constitutional scrutiny?
It's a very abstract question because it doesn't sound like reparations in the form we usually think of them is likely ever to pass Congress. And it would be, I guess it could be attacked as a form of affirmative action, which the Supreme Court nowadays doesn't like very much. But I think a reparations program that was not based, that made sense, could pass or could be upheld. And what I'm thinking about is the many ways in which the government has helped to create a white middle class and white wealth while denying it to African Americans and other minority groups. And the best, we have some discussion of that in the book about the huge difference. For example, as discrimination has waned a little, the annual income comparison between, say, white and black is moderated. So nowadays, in general, we think that white family income averages about 1.5 times black family income. But what is hugely different is wealth, net worth, how much your house is worth, how much you have in the bank, that sort of thing. And there, the difference is 10 to 1. And most of that difference comes from what we call intergenerational transfers. And a lot of that comes from government programs, even in the 1940s and 50s and 60s, where federal government subsidized the building of new suburbs, which were almost all white. other kinds of things, even the Hill-Burton Act that poured billions of dollars into hospitals had a provision that said segregated hospitals are okay, and we'll put money in segregated hospitals. And that included segregated teaching hospitals so that medical schools were getting money for white medical schools and black medical students were going nowhere. So I think if a program were keyed to that kind of imbalance and justified based on that imbalance, it could get somewhere. But it would have to be carefully tailored and carefully explained, because otherwise it would just be derided as a handout for whatever.
Right, right. And another question from Greg Howell for Dr. Burton. Could you discuss how the 14th Amendment, which was meant to ensure former slaves were treated equitably, is now being interpreted to prevent the government from making blacks whole for past discrimination, Jim Crow, and segregation?
Yeah, I may not have heard all the question, but Armand and I had this long discussion we tried to boil down in the book because it really bothers me as a historian. If you look at the evidence, the intent of the 14th Amendment, well, Armand's talked about it. Earlier, I just remembered what that amendment and why it was passed. And yet 80% of cases, certainly in the 20th century, I forgot exactly what years, have been for corporations under the 14th Amendment to benefit them. And now the irony is how the 14th Amendment is being used by white people to fight what we think of as affirmative action, though as Armand just pointed out, it was affirmative action for whites only with the New Deal for some number of decades. It helped to really explain this difference in wealth accumulation over the years. And one of the ironies even there is Armand and I were in writing up our affirmative action sort of sections and chapters. What that inspired was good historical research that if we'd have had it earlier, would have answered the questions that allowed the Bakke case to go forward, that we didn't have the evidence there that then knew about the Hill-Burton bill discriminating and where African Americans got medical education and things like that. So it's rather a catch-22 now. I didn't quite understand your question, Robert. Armand, you might want to take it. Did you hear the question?
I think you've gotten across the good answer.
Did you? I didn't quite understand. I just heard the 14th Amendment and then I go off on a tangent. So I'm not sure what the question was, Robert, if I did it.
That basically answered the question about how the 14th Amendment was started to do one thing and how it's been interpreted so vastly differently since then.
Yeah, well, it's particularly something that I hate to say that I'm a little irrational about because I can't understand how they could have possibly done it, to be honest with you. And Armand might be better able to explain it as a legal analyst because he tried to explain it to me, but I never have understood how they could have possibly.
No, it was a combination of things because the Supreme Court was in the 1870s and 80s and 90s was draining the 14th Amendment of any meaning for African Americans, and at the same time they were discovering, quotation marks around the word discovering, that it was really meant as a charter of freedom for corporations and businesses, and making sure that states could not regulate working conditions or things like that. So it was a combination of both those things at the same time. It's quite an irony.
Yeah, it's more than irony, it seems to me. But yeah, it's awfully deliberate, it seems. But again, what I was saying earlier, it probably did reflect where a lot of Americans were. And it's also a good example if you don't stop it, where it can go. I mean, if we could have stopped it then, maybe you wouldn't have. I mean, one of the great ironies, I think I talked with you about Ben Tillman once. I believe it was this group and things. And, it's like everything's so complicated. Citizens United overturned what reform? It was the Tillman Act, which tried to keep big money out of politics and corporations. I mean, here you go. You've got this man who represents the horrors, as we can think of it, of segregation, but is, at least in my opinion, was trying to keep corporations where we are dealing with the issues that Citizens United let loose those demons in our society and dark money in a different way. So it's what I'm talking about, the ambiguity of reading history. Most of us are complicated people. We do things that we probably shouldn't, and some things we do that are really good. And I think that's the way we have to look at our history and read it to understand it.
Let me just say this. There's a quote on page 342 of the book, near the end of the conclusion, where there's a quote from the Supreme Court in an 1873 case called Slaughterhouse Cases that explains exactly what the 14th Amendment, the 13th and 14th and 15th were designed for, to help the newly freed enslaved people. And it said this is from the perspective of justices who lived through the Civil War and lived through the time of those amendments. And it says exactly what the 13th, 14th, 15th Amendments were designed for. And yet very quickly, the Supreme Court went in a different direction and abandoned that. But if you want to see what was the original, again, the quote, original understanding of what those amendments for, the Reconstruction Amendments, look at the quote on page 342.
All right. The next question we have here from Derek Jackson, I think it's a rather intriguing one. I'll post this to Dr. Burton first. Have you ever had a discussion around the question Judge Roger Taney raised in the Dred Scott case of 1857? Most people discuss his answer, but never speak to his question.
I guess I have to ask the question, because there's so many questions actually. But one of the main things that it shows that both Armand and I spent a lot of time on this, and if you want to see more about it, you can go on our website. We recommend. There's a lot more on this case there. We had to cut it down, or it would have been the length of the book. But this is one of those great examples, where what he is trying to do and what he understands it is, he's going to come up with the answer that's going to keep us from going to civil war, which pretty much has the opposite effect. And Armand likes to tell the story, and I want to leave it to him, of the great seer, President Buchanan, who's going to let this case be the answer to everything. So I'll leave that to you. But one of the most amazing things is how, if you look again at the dissents in this thing, you see the other side of the Dred Scott case. For instance, that they had never been citizens in the slave state of North Carolina. Free African Americans voted on the same basis as whites did. And they even made a difference. When I did I investigated when I did the felony disfranchisement case just last year, the year before in North Carolina, quite literally, they influenced elections. That was part of the reason that certain whites wanted to stop them from voting after the Nat Turner insurrection. But you had that. But if you look at Dred Scott, and it's also Harriet Scott, that's something else we're proud of, that she was part of this case as well. You look at it, and it's as the lower court judge said, even in South Carolina and Mississippi, Dred Scott would have been declared free, and he would have been in Missouri. And the judge said, things are not now as they were, meaning we're at this crisis point in the Union. So they ruled against precedence in terms of Dred Scott. And that Dred Scott didn't have to go to the Supreme Court. The Supreme Court could have just said, could have ended there. It was Dred Scott. It was Judge Taney who went on further to make the statement that African Americans had no right, of which he, as I said, was wrong about. But one of the things that really interests me, and this is not in the book, and probably Armand was right not to, because we beat up on Judge Roberts pretty badly. But one of the things Judge Roberts said, getting to the Shelby County decision that gutted the Voting Rights Act, is the act that brought really Armand and I together, is that almost are the same words. When he said things are not as they were, when he said that in 2013. And he's sort of right, it's getting worse. But at any rate, that's not what he meant. And then in a court case that Armand, a real seer, sort of predicted, and I went along with him, the Bronovich case, literally, which came out after the book, but we predicted it in a footnote of what it was going to say. Judge Alito says almost the same thing. Today is not like 1982. So it seems to me every time that people want to talk about and rule against minorities, they just say, oh, look how much better things are. And it's not as they were. As a historian, I cannot let go of that pattern. Even if it's not in the book, it is there in terms of these justices saying these sort of things. Now, I don't know what question he's particularly asking about. Do you, Armand?
No.
Yeah, let me, Robert Derek, specify your question, please. Go ahead.
Okay, the question he raised in that Dred Scott case was, he says, quote, "The question is simply this: can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights and privileges and immunities guaranteed by that instrument to the citizens?" Yeah. That was the question he raised.
Well,
I'm saying that question is still a question today.
Well, I don't know who's
I don't. Well, I think
because, as I said, when he said that, he's just dead wrong. They had been. They were voting in North Carolina and 4 other states. They were there when it all came about. They fought in the American Revolution, overwhelmingly, unproportionately so, as part of the regular army. So, that was just his way of trying to get rid of Black citizenship, I think.
I think what the questioner, I think I see a deeper meaning in the questioner. On one level, okay, there's 3 answers to the question. Tawney's answer was no, and that was the decision because he had 7 votes out of 9. So the answer on that one was no. Secondly, the 14th Amendment specifically says yes. That is, the first sentence of the 14th Amendment says, every person born in the U.S. and subject to its jurisdiction, which means not ambassadors from other countries, is a citizen of the U.S. and of the state in which they reside. So the 14th Amendment said yes. But I think what your question is it's sort of a philosophical question, because the 14th Amendment says yes in a technical sense, but what we have been trying to do since the 14th Amendment is to make that a reality. And you're asking, will that be a reality? Can it become a reality? And that has to do with the future and everything that the people in this room and all our friends and allies are trying to do. Is that what you're getting at?
Yes, I was getting at, and the fact that legislation all over this country among states is regulating as if we're not citizens of this country.
Not necessarily. I think what's going on is that the legislatures have decided that it's not just African Americans that they have to worry about. They don't, there's a lot of people they don't want voting. African Americans, other minorities, older people, handicapped people, students. Younger people. They have a clear idea of who they want to vote, and everybody else want to get out of the way. So in a sense, you're being joined by other disfavored people because, as Vernon says, there's a new majority in this country, and the people who temporarily, I believe, have their hands on the levers of power in state after state, including this one, want to make sure that that majority does not rule, that we do not have a democracy. And I guess we wrote this book in the same hope that you're expressing, which is that the better view, the better angels of our nature will prevail.
And I think young people do not want to be prejudiced. I think they want to be fair. I've been so uplifted by not just Amanda Gorman, but so many. Let me give you one other. I thought about why history can be illustrative. I want to be careful to say, you know, people too much want to say Vietnam and Munich or, you know, make those kind of parallels. But what is true is that our history is where we come from. Our future, where we are now, we were there before and we have emerged or gotten to this place. So it's important. And then secondly, where we're going is determined by where we are. And one of the things we talked about Brown before we got there, and why Armand was hoping that Jimmy Burns would have gotten better, is this. I found, and I think Armand did too, a new hero I didn't know about. I was sort of prejudiced against him, and that's Chief Justice Hughes. You know, I did my graduate work at Princeton. Armand did his undergraduate work there. Well, before the last few years with what we call the woke movement, and particularly at Clemson, Woodrow Wilson was extraordinarily held up as the model of progressivism. And I still think rightly so on some of the good things. He's really the first one that took on the corporations and particularly big business, and was the first one really supportive of labor, things like that. A little bit of TR, but that was more corporations than the business community. So the man that ran against him for president was Charles Evan Hughes. And so I saw him as this big corporate lawyer, which I don't have a real affinity for in my heart, growing up as I did in '96, South Carolina. But then we got into it, and I think Armand agrees with me, at least he was central in how the court got to be a good court. Because up until Charles Evan Hughes was on the court, if South Carolina said, look, you know, we read this Constitution. It does not say we are disfranchising Black people. It just says that people who can't pass a written test and that African Americans don't have the education, they're the most people who can't. It's a fair test. It's a race neutral test. And the Supreme Court of the US said, yep, you're right. We're not going to overrule it. You're exactly right. Then Charles Evan Hughes, whose father was an American Baptist missionary, if you know anything about the American, and an immigrant, if you know anything about the American Baptists, well, they're the ones who supported Martin Luther King Jr.'s, Morehouse College, had the insurance policy for his family. They were very good on race. And his son, Charles Evan Hughes, stays with that denomination and takes a very serious part in it. And when Arkansas and Alabama and South Carolina said, well, you know, we think these laws are okay, Charles Evan Hughes said, send me the evidence. I'd like to look at the evidence. And that began the turnaround. And as a historian, I believe in this. Let's hope the same way that if we can get the evidence to the Supreme Court, they will have no choice that if they claim to be originalist or textualist, that since the 13th and 14th and 15th Amendment are part of the Constitution, they're going to have to rule the right way or have some mighty hard explaining to try to do. So that's another reason that I think there's hope there, unless it's just there are a few justices, I think they're just so bad, you're not going to be able to thing with them. But I'm hoping that some others can come to see if we give them the evidence. And that's why I started out talking about the importance of evidence. And that's where Armand and I say the turnaround begins, is when the court itself looked at the evidence and just didn't take the word of the state Supreme Courts or governors or others. You want to
the
modify that?
Turnaround also requires that we not pay too much attention to the Supreme Court when they're leading us astray. You yourself say, Vernon, remember that this is a government with three branches, the two political branches, and the Supreme Court should not be running the show.
It means, though, Congress just got to step up, and it's very hard when we're so bipartisan. You know, I'm not even sure we were this, at least the partisanship wasn't, it was much more regionally contained at one time, and now there's a lot of rural, urban, and other things. It's a very difficult political situation now, and how to contain it and maintain it, I think.
All right, so we've got less than 20 minutes left for today's conversation, and there are quite a few questions left in the chat. So here's the next one from Don Murphy, and this is for each of you. We'll start with Mr. Derfner, then go to Dr. Burton. Would each of you recommend 3 books that impacted you? Start with Mr. Derfner first.
Oh, let me give it to Vernon. Let me think about it for a minute.
All right, Dr. Burton, go ahead.
Well, the Bible was probably the most important for me, along with my sort of faith, and the faith-based is the way I grew up with my mother as a role model. Probably her role model was more important than any book. But then I read C. Vann Woodward's Agrarian Rebel, which was a very, very, Tom Watson, Agrarian Rebel, whether historically right or wrong, was very powerful. And then there are a lot of other books, you know, there's so many that were written, but to give you a fiction book, about the time of the Orangeburg Massacre, when I was in college, a little part of SOC, SSOC organization, I read a book called 5 Smooth Stones about the civil rights movement that I remember really. It's a book, I can't remember the author now, but it was a powerful book reading during my years at Furman about my sophomore year. And I think that was one. And of course, there are a lot of other things later. I mean, King's own, you know, letter from a Birmingham jail, which are a book or not a book, but very powerful. Introduced me to James McBride Dabbs. Then, of course, my own local hero, who I now wrote the foreword to, but when I met Benjamin E. Mays at Furman Religious Emphasis Week in a little seminar where we all introduced ourselves, time I thought I'd be a minister, but the religious professors at Furman really cared about Christianity and thought the best way to save Christianity was to keep me from becoming a minister. So I went off to be a historian on their recommendation, though I wanted to do the other. But I then read Born to Rebel, which really focuses a lot on South Carolina. And then Dr. Mays asked me to write the foreword to the next edition of it. So that's more, but I guess the 3 history ones would be the Bible, and then Woodward's, that book, along with his Strange Career, Jim Crow, and then Dr. Mays, I guess, Born to Rebel. So those would be the 3.
I'll pick sort of 3. First is a pair of books by George Orwell. One is 1984, and the other is a book called Animal Farm. And Animal Farm especially is about the essence of democracy. And so I think those are the second, Julius Caesar by Shakespeare. And third is a book that probably almost nobody in this audience has ever heard of, The Autobiography of Lincoln Steffens. It's a book I read in high school. I was assigned to read it. Lincoln Steffens was one of the original muckrakers and became a reformer in the early 20th century. And there's just so many lessons for life and government in that book. So those are what I would read, along with lots of others, including The Age of Lincoln by Vernon Burton.
With that, I got to say, I think before you go away, you've got to have Armand tell the Miss Mary Hamilton story. And then I think you should ask Armand.
Let's get some more questions. They can
I
read
think,
that.
Armand, people would like to hear your story, though, about how you became a civil rights lawyer, leaving Mississippi. I think that's an important story. I know you don't want to, but it's important.
I'd rather hear some questions from the audience.
Okay.
We've been shooting our mouths off for a long time. Let's give them a chance.
All right, very quickly. This is for Dr. Burton. Here's a question from Derek Jackson. An economic interpretation of the Constitution of the United States by Charles E. Beard. What is your opinion of this work?
Well, that was the book that influenced C. Vann Woodward. I like it very, very much. And it's also, he was influenced by his wife, Mary Beard. It's one of the few places that starts talking about the influence of women. I think it's overdone, but I think it is a very important book. And one of the problems with the history that I did and others, like the social history I started with and cultural history, is we do forget the essentialness of economics and politics, that these laws really do matter and affect people's lives, which is what Beard was saying. So I really consider myself as sort of an heir of Beard Woodward interpretation. And one of the big differences, and I'd love to talk with people about this sometime, is when I grew up in 96. Well, I grew up outside of 96 in the country, but 96 was the largest community. And we knew there was class. There was segregation, black and white. But then the cotton mill kids had to go to a separate school until they learned that was what their life was all about. They should never do as well in school as the kids like us from the country, in particular the town kid. But there was class. I used to jokingly say, of course there was class. They played golf and we went fishing, but it was more than that. I have come back home and I don't see whites who identify themselves as anything but white now. And they all think they're middle class. And they also look at black people as othering, and they other them in a way that I don't think was there. I'm not trying to say it's like Armand, it's better than the violence and the oppression and that people can vote than when I grew up. But at the same time, somehow we have conflated the issue of class and made basically the South of white and black as substitute for class. I don't think that's the reality, but I think that's become the cultural use of it there. So I think that's different. And I think that's going too far away from Beard and economic history. And part of it's our fault in the history profession, because it's much more fun to write about other things like, rock and roll or other kind of topics or baseball, Armand, than to look at class and economic issues and how that do in ways influence society and the strata in society. So short answer, I like Beard, but probably most historians today wouldn't pay much attention to him.
Well, let me throw in another thing. I like Beard too, and I would agree with Vernon. He's solid but overdone. But if you look at it, if you're a Beardian, then you would tend to support Thomas Jefferson and Andrew Jackson. Well, they may have been more for the common man, but John Adams and John Quincy Adams were a heck of a lot better, and Alexander Hamilton were a heck of a lot better on race. So,
yeah,
nothing is a simple answer in this world.
Well, to that point, Mr. Derfner, you're up next with this very complicated question from Christina Eisenhower, which you actually kind of alluded to already. This question is complicated, and I know it is a politically loaded question.
Okay.
But there has been talk about the legitimacy of the Supreme Court. There are concerns about the court overturning presidents. There are conversations about adding justices to the court. From your perspective, how do we reckon with these conversations and concerns about the power of the Supreme Court for impacting generations to come on issues of civil and human rights?
I think I'm probably too much of a traditionalist to be in favor of packing the court by adding more justices. Although, frankly, this court is getting so bad that I may just change my mind on that one. But I think the most important thing is a recognition, and maybe that's what they were accusing the Warren Court of, that the court has so much power, power which it took by itself, and a feeling that more and more questions should not go to the Supreme Court. We should not we should not let 9 people, especially sometimes if it's 5 to 4, one person decide national policy on huge issues that tens of millions or hundreds of millions of people disagree on so fervently. And there is a school of thought, for example, that says, well, you know, if the Supreme Court had not decided the issue of abortion in 1973, we might have a different situation now, because states one by one were loosening rules, were eliminating laws that made abortion a crime, and we might have had a better result in the long run. And I'm coming more to that view, especially that the Supreme Court gets to decide too much. And it's not healthy for a country. And frankly, if you look at the whole history of what our book describes, I'd have to say that if there was no Supreme Court at all, this country would have been better off in a racial sense, in our racial situation. So I guess more and more, I want the Supreme Court not to be deciding questions, and us as a democracy to be taking things away from the Supreme Court. How we do that is another question.
I would probably disagree a little bit, Armand. We'll talk about it off.
Okay.
Off
We
camera.
disagree on a lot of things.
Yeah. No, I think the Supreme Court was where the country was most of the time. It's not now. I think that's one big difference. But I'm not sure it would have been better if you had not had a Supreme Court. I go back to Lincoln and the rule of law. What are our alternatives?
Well, our alternative is to have Congress, like in England, have Congress, have Congress make rules. They're our legislative body. They oftentimes go off half-cocked and come up with really screwball things, but oftentimes Congress has been, like right now, well, until recently, Congress was a heck of a lot better than the Supreme Court was. The Supreme Court spends its time declaring some good laws of Congress unconstitutional.
Well, one of the problems is we're not a parliamentarian form of government, and that's really effective. It's a winner take all.
Yeah.
And if you don't like because somebody wears pantsuits and a woman, and so you vote for a third party.
And we have a two-party system.
Then, that's right. You forget that the president gives lifetime appointments. In fact, not only to the Supreme Court, but to the federal judges, which we haven't really talked about, but where most people's lives are most affected in those federal judge opinions. And so it really matters who you vote for. And it would be nice if we had a parliamentarian form of government, but we don't. And I think that's really makes it hard if you don't have a Supreme Court.
One specific recommendation that I have is we ought to have term limits. Yeah. And this would require a constitutional amendment. We ought to have term limits for the Supreme Court.
And federal judges.
Okay, too. But the point is the notion that especially the justices are getting healthier now. The average tenure for justice nowadays is 25 years. It used to be half of that. With 25 years, it means justices are making our policy, especially since they are, quote, the last resort, they're making our policy for generations after they have been out of their, quote, prime. I took my mother to the Supreme Court one day some years ago, and after we left, I said, well, what did you think? And she said, this is before Justice O'Connor came. My mother said, well, who are these old guys trying to run the country? They should be home playing with their grandchildren. And I think there's a lot to be said for that. So the one specific, I would say, is term limits for Supreme Court, perhaps other federal judges, of 20 or at least no more than 25 years.
All right, so this will be our final question for the evening. This is from Cecil Cahoon. I'll direct this to Dr. Burton. I perceive that civil rights activism won the legal fight, but white conservative resistance has dominated the political fight. Otherwise, we wouldn't continue the struggle today. Your published works highlight the internal stories that led to legal success of civil rights activism. However, he also says, I'm unable to find equivalent publications that describe the internal stories that led to social and political success of white conservative resistance. Clive Webb's Massive Resistance is great, but not specific to South Carolina. There's nothing in the biographies of Sol Blatt or Jimmy Burns, and no biography of Marion Grissett. Can you direct me to scholarly works on massive white resistance and its victories in South Carolina?
Yeah. Well, in the book I edited out of the Citadel Conference I did as a Mark Clark chair that year, John White has a good essay on massive resistance. I think it's mainly Orangeburg. There are a couple of works on that. You can look at works, particularly there are a couple of good biographies, a recent sort of, I would call it a biography. Wouldn't you call Judge Gergel's biography? Yes. Yeah. A biography of Warren, talking about the massive resistance movement there. But there's an earlier book too. Tinsley Yarborough has a biography of Warren, and it's there as well.
But the question is books about how the right wing went crazy, and not just in the 50s and 60s, but what they do. A book about, for example, the Tea Party. Are there books about that?
Actually, there are.
There's some coming out there, but again, he wants specific to South Carolina, right, Robert? Yes. What I'm thinking of is like the book on 1974 that, why am I blanking? A cruise, and I was on that congressional hearing with him. I can't remember. Oh, shoot, I can see him. He's on CNN all the time. The other Princeton professor, Zelzer, written about the 1974, 1970 years. There's a number of things that journalists have done. I think Ari Berman, who quotes you a lot, Armand, and relied on you, his work is pretty good.
I think again, one of the books, a book called by Stuart Stevens, published about a year or two ago, called "It Was All a Lie." Stevens is a Mississippian who has been a Republican strategist, and I think was, for example, one of Mitt Romney's advisors, and may have worked for John McCain as well. And that book, I think, has a lot to say about how, about describing the rise of the radical right wing in the last few years.
There is a book that was published, I believe it was University of Kentucky, and I know him well. I'm blanking on his name. We've been going a long time here. Several of you will know it. And its subtitle is something like Civil Rights, subtitle, Civil Rights Movement in the South. It doesn't come up to the modern period.
But the modern period is what we need, Vernon.
Well, yes and no. But there's a good bit of stuff that's been developed on Harry Dent and Lee Atwater and their influence by political scientists, which is where so much of what I was talking about earlier, these code words and appeal to what had been white Democrats to become part of the Republican Party, conservative white Democrats. A good bit of that would be relevant, I think, to the kind of things he's talking about. But specifically on South Carolina, one of the tragedies, if I live long enough, I hope to do something about this, is we created this myth on South Carolina. Of course, we're not like those rednecks down in Georgia, Mississippi, and Alabama. Well, look at Clemson. We have integration with dignity, when the truth is I said just the opposite. Last state to integrate, using the laws with the brilliant Jimmy Burns strategy, using residential segregation patterns. All these things have been why South Carolina, but we also are good at creating this myth, like the tragedy of Reconstruction, just the opposite. Reconstruction, the most progressive period in American history, most progressive constitution we've ever had. So we have been, Armin.
Vernon ran a conference at the Citadel, a dozen years ago with Bo Moore. And I remember very specifically, Steve, what's his name, did a paper on desegregation in Greenville, South Carolina. And he said, his thesis was, everybody says, and Greenvillians are proud of the fact that they desegregated politely and without stress. He says, well, that's certainly true if you think politely and without stress includes repeated lawsuits, 7 contempt citations, violence, et cetera, et cetera. if you want to call that peaceful and without stress, that's it. So Vernon's Citadel book would be a good source for that too.
But
do you remember the title of it? What's the title of it? Vernon?
Yes, Toward the Meeting of the Waters.
Mm-hmm.
Toward the meeting, and then the colon civil rights movement and that. But what I really think that has hindered people to look at South Carolina because Lau, LAU is the person who wrote the book I was trying to think. Peter Lau, his book on the civil rights movement. But so they're more interested in Mississippi and these other states, but South Carolina was central to the civil rights movement. Even, most of us like to point to, you're talking about cases, the Rosa Parks case referred to the South Carolina case, on desegregation of buses. I mean, you just go on and on and on with how important it was, but they have been good legal strategy. But they created this mythology that we bought into, and it's a nice mythology. That's why they don't know about the Orangeburg Massacre. Mm-hmm. We didn't have things like that happen in South Carolina. And people don't like to remember bad things. I learned that the hard way doing these court cases. They just don't. Memory doesn't work that way. You don't want to dwell on these bad things. And the one I remember most was a Mullins case where the woman was on the stand. She was a school. She'd grown up in segregated schools. Her children had gone to segregated schools. She taught in segregated school. And so Lawker McDonald asked her about segregated school, and she said, "Oh, were they segregated?" She didn't remember they were segregated, and she wasn't lying. And she even asked, "I wonder why they were." People, and this is the way we think. So it's unpleasant to go back, I think, and deal with the truth.
Another thing a person could do would be reading the newspaper stories about what has happened to people, political figures in South Carolina in recent times who've gotten the slightest bit out of line. When Mark Sanford, as a congressman, was defeated in the primary because he was a little bit disrespectful of Donald Trump. Now Nancy Mace is getting the same. Tom Rice in Myrtle Beach. Read the newspapers about what they have been subjected to. These are people I don't necessarily agree with, but that's an example of how the right wing. Follow Lindsey Graham's career.
Dr. Green, let me interrupt. This guy's not going to stop. I want to point out to people that haven't been through the entire Modjeska School that we started a school to do exactly what the question is to connect the dots, bring the modern as to the work of the winners, who happen to be the right-wing folks that we're talking about, and the patience and the diligence and the discipline that they had that the liberals lacked in South Carolina. And so that's part and parcel of the Modjeska School, teaching the people's history of South Carolina, not the winner's history. So there you go. Armand, we expect to see you and Vernon back in class. Dr. Green?
Well, again, I want everyone to thank our guests this afternoon. Please give them a wonderful round of applause. They definitely deserve it. And tomorrow's class at 6:30 p.m. will be about the Reconstruction era in South Carolina, and also showing the backlash to that era as well.
Thank you for inviting us.
Well, thank you for still being here, Armand. You're a national treasure. We're going to keep you around for a while. And Vernon, I believe you're welcome to come tomorrow if you want to help kibitz about Reconstruction. You're certainly welcome. We talked about that earlier.
Well, Armand and I are speaking here. We're both in Charleston right now, so we're speaking here at 6 p.m. tomorrow night at the Avery Center, and we'll call it the Charleston Library.
Spread your bread widely upon the water, my brother.
Thank you all.
Thank you. Bye-bye.
Thank you for the good question.
Good work, you two, Brett and Robert. Thank you.
We'll be in touch.
All right. Bye-bye.
You'll get your T-shirts.
I want one, yeah.
All right.
2.
Thank you, Dr. Green.
Thanks.
Thank you.